Hello and welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. Today, we are going to discuss a very important topic. The complete judicial process of a civil case, in which we will cover 18 stages that take a case from filing to final judgment and decree. This information is extremely useful for common citizens, law students, and even young lawyers. Stage 1: Preparation of the plaint. A civil case begins with the plaint. This is a written document prepared by the plaintiff, which includes complete details of the dispute. Who is being sued? Defendant. Which legal right has been violated? What relief the plaintiff seeks, such as compensation, injunction, restoration, etc. This is the foundational document and sets the course of the entire case. Stage 2: Court fees and attachment of documents. Along with the plaint, court fees must be paid, which are calculated based on the amount involved in the suit. Necessary documents, evidence, identity proof, property papers, or other annexures are attached. A verification clause is added to affirm that the information provided is true. Stage 3: Scrutiny by registrar and registration of case. After the plaint is filed, the court registrar checks if all documents are complete. If there are errors, an opportunity is given to correct them. If everything is in order, the case is officially registered and allotted a case number. Stage 4: Issuance of summons. Now, the court issues a notice or summons to the defendant, along with a copy of the plaint and details of the next court date. This is served with the filed petition. Stage 5: Service of summons. The summons is served to the defendant by the court bailiff, speed post, courier, or registered post acknowledged due. RPAD. If the defendant is unavailable, the court may order publication of the summons in a newspaper, substituted service. This ensures the defendant is informed. Stage 6: Written statement. The defendant usually gets 30 days to file a reply, written statement. In this, the defendant denies the allegations, may file a counter-claim if required, presents factual and legal grounds for defense. The court may allow additional time under special circumstances, up to a maximum of 90 days. Stage 7: Replication by plaintiff. If required, the plaintiff can file a reply to the written statement known as replication. This is the plaintiff's response to the objections raised by the defendant. Stage 8: Framing of issues. Now, the court studies the pleadings and documents to identify what are the actual disputes between the parties. On which legal and factual points the decision needs to be made. These are called issues, such as 1. Did the defendant unlawfully occupy the property? 2. Is the plaintiff entitled to compensation? Stage 9: Plaintiff's evidence. The plaintiff must now submit a list of witnesses to the court. Present witnesses for examination in chief, where they narrate their side of the case. Defendant has the right to cross-examine them. The plaintiff also submits documentary evidence at this stage. Stage 10: Defendant's evidence. Now it is the defendant's turn to present witnesses. They testify in chief examination. Plaintiff's lawyer cross-examines them. Stage 11: Rebuttal evidence. If the court feels that further clarity is needed, both parties may be allowed to present rebuttal evidence to counter each other's claims. Stage 12: Final arguments. Now, both lawyers present oral arguments. They interpret the law, refer to precedents, case laws, and analyze evidence. This is the final presentation before the court. Stage 13: Judgment reserved. After arguments are completed, the court prepares the judgment. In some cases, the judgment is reserved, meaning the court will take some time to write it. A date is fixed on which the judgment will be pronounced. Stage 14: Pronouncement of judgment. On the designated date, the court pronounces its judgment. This is a written decision stating which party is granted relief, on what grounds the decision is based. The judgment is recorded in court records. Stage 15. Preparation of decree. Based on the judgment, a decree is prepared. This is a conclusive document that ensures enforcement of the court's order. It clearly states what has been ordered in favor of which party. Stage 16. Execution petition. If the losing party fails to follow the court's order, the winning party can file an execution petition. The court then enforces the order, for example, by attaching property, freezing salary, etc. Stage 17. Right to appeal. If either party is not satisfied with the decision, they can file an appeal in a higher court within the prescribed time. Examples: from civil judge to district court, from district court to high court, from high court to Supreme Court. Stage 18. Final conclusion. Once no appeal is filed or the appeal is finally decided, the matter is considered completely concluded. Thereafter, the decree is implemented and the party receives its lawful remedy. So friends, this was the detailed explanation of 18 stages of a civil case, which every Indian citizen should know. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.